Members, I'm going to reconvene our committee and bring House File 50 back up. That's where we left off. That's Representative Hornstein. Representative Hornstein, where we left off was there was still some testifying that was going on. I think the gentleman I had offered, Mr. Hallier, to finish his testimony. So perhaps, sir, if you can come forward and do that, and then we'll see if anyone else wants to testify. And then hopefully we'll take questions and then move to a vote. Welcome back, Mr. Hallier. Please restate your name for the record and give us, finish your testimony, please. Thank you.
Thank you. My name is Brett Collier.
Collier.
From Big Lake.
Mr. Collier, how do you spell your last name?
C-O-L-L-I-E-R.
Yeah. Thank you.
First name Brett, B-R-E-T.
Thank you. Please proceed, Mr. Collier.
I believe where I left off was there is another bill in the House, House File 104, that wishes to increase the current $50 fine to at least $150 and then up to $500 for third offense, with the Senate version wanting to actually revoke your license for a period of time following the third offense. This is a sound and logical path that Minnesota should be taking. This is an increase in both the penalty and deterrent for the actions which are actually causing distracted driving deaths. But let me remind you, if both this hands-free bill and the increased fines bill were to pass this session, you are going to be charging people who are simply holding the phones to their ear a penalty of at least $150 and possibly revoking their license for performing an activity that, again, statistically is not a major contributor to distracted driving deaths here in Minnesota. What are the proponents not telling you? The proponents continue to tout that there are 13 of 14 states, although I guess the flyer that's in the back has says 12 of 15 states now, in which, when they implemented a hands-free bill, have seen a drop in distracted driving deaths. What they fail to tell you is that in Vermont, for example, they instituted both a statewide ban on texting and driving at the same time they instituted a ban on hands-free. So you simply can't point at the hands-free ban as the sole reason for the drop in deaths. So what other facts are the supporters of this bill leaving out? It's been recently reported that the average number of distracted driving deaths from 2012 through 2017 in Minnesota was 53 per year. I got that out of the Star Tribune. Besides this being a drop from the 2015 number of 74 deaths, remember, when I'm talking 53 deaths, 74 deaths, we're talking about all types of distracted driving deaths, not just ones involving the use of a phone. Please don't let your emotions cloud your judgment. Please use your common sense and the data. Thank you. Any questions?
Thank you, Mr. Collier. Are there any questions for Mr. Collier? If not, then thank you, sir. Thank you for hanging around and finishing your testimony. I appreciate it.
No problem.
Is there anyone, I do know that Representative Miller has a question. He's on top of my list, but I want to make sure there are any other testifiers on this bill. Please come forward. Welcome to the committee. Our practice is to state your name for the record and then give us your testimony.
My name is Yark Tikalski. Last name Tikalsky. So, as I just said, my name is Yark Tikalski. I'm from New Prague, and I'm 16 years old, and I have had my license for a little under a year. Since my grandpa Joe was killed in 2015 by a mom who was texting her daughter, I, along with my family, have been working to make our roads safer. We've spoken at high school assemblies, to driver's ed classes, and testified at the state capitol. I'm very frustrated with how long it has taken the state of Minnesota to make a decision that 17 other states have made. My family has been testifying for almost 4 years now, some families for almost a decade. Every year we've come across a loophole or a new obstacle. Watching the hearing on TV today, we heard from representatives' concerns about racial profiling. I think it's unfair to stop someone because of their background. But if they are holding a phone while driving, they are breaking the law. I can't tell you if the driver who killed my grandpa is Irish, German, or Jewish, but I can tell you that grandpa won't be at my graduation next year. Distracted drivers do not discriminate. Every year, our messages have been the same. We provide you with facts and statistics, and we tell you our sad stories and show you our loved ones' faces. The only thing that does change is the number of Minnesotans that are killed due to distracted driving. The members in our club continue to grow. Now we are hearing some legislators think it would be okay to hold the phone for GPS uses, even though the phone tells you where to turn next. I'm 16 and I know 2 hands on the wheel is safer than 1. Please don't give drivers another excuse to hold their phones. Please pass a clean, hands-free bill. Thank you.
Thank you, Mr. Tikowska, and please accept my condolences and our sorrow for your loss. I believe I speak on behalf of our entire committee, and I take it that's Grandpa Joe's picture there behind us.
It is. Thank you.
Thank you. I believe we're ready for questions, and Representative Hornstein, or Chair Hornstein, Representative Miller has a question.
Thank you, Mr. Chair. Thank you, Chair Hornstein. I think I had a conversation with the chair. We kind of ran into each other in the hallway, and I just want to reiterate just a couple brief things that I said. I think first of all, on a bill that, as you're right, seems to be a lot simpler than we seem to be making it, but I think your bill is heading very strongly in the right direction. I also know that there's some other bills that are coming down. One of the things that I've realized is, in my opinion, we all agree that we don't want people that are distracted driving, because they become, as we talked about drunk driving the other day, become a weapon, right? And a very terrible thing happens. So I'm very sorry for your loss and the losses of the others. The question that I have, it doesn't need to affect how your bill moves forward, but I don't know if Mr. Chair, if there's other bills moving forward, or as we move forward and discuss this. The other night, or last night, when we were talking about the exceptions in one of the bills we were talking about, we listed them, and there was that discussion about how when we start listing, we end up missing things when we start listing. And so when it comes to this, by far and away, things related to the cell phone are causing the most distracted driving problems. But that doesn't dismiss the fact that we have other forms of distracted driving. Some of them may be more serious than others. You know, maybe a cup isn't as serious for one person as it might be a hot cup of coffee for another, spilled on their lap or something like that. Is there a way, Mr. Chair, or Mr. Chair, as we move forward, the one thing, and I totally get the issue related to phones. I get it, because it's clear and present, and it's a huge deal. But is there a way, perhaps, that we can empower law enforcement to make a determination that someone was distracted driving and have things associated with the fact that it was distracted driving, and not necessarily just the tool by which they were being distracted by? I don't know if that makes sense to you of what I'm trying to say, but this will take, we have something that's not hands-free, and I'm not asking you to change this bill at all, but we're addressing one problem, but I can tell you the hot cup of coffee, or that spills, or a dog on your lap, or some of these other things are kind of some legitimate things as well. And I just think, again, in context, I hate to be redundant on this, but just to be clear, you know, when we make a list of things, we miss things on the list. Is there a way that we can empower law enforcement? So I don't know if it's to you or to you, but if someone can kind of respond to that, that'd be helpful.
Mr. Chair, I can answer that.
Oh, okay, hold on a second. Let's start with the author of the bill. And then I believe our lead, Johnson, has some thoughts, and I have some quick thoughts as well. Chair Hornstein.
Thank you, Mr. Chairman, and Representative Miller. That's a good question. I think there is a law that I think does cover all the things that you had mentioned. And there is some discretion for law enforcement if they see that kind of activity and they see, you know, drivers that are not obeying basic traffic laws. But we did, I authored the texting bill in 2008, and this very issue came up on the House floor. And my response, Mr. Chairman, Representative Miller, is that I think the texting and cell phone use are sort of in a category among themselves. And I say that because they are proliferating at such a high rate that this is really the number one form of distraction on our roadways. And what we're doing with this bill is, I think, enhancing this is really just adding on to that texting law in a sense. It is, as the gentleman who just testified pointed out, same penalties. We're not changing the penalties, et cetera. Maybe that's a separate conversation that what we can have with Representative Detmer's bill. But I do believe the things that you were mentioning are covered currently.
Okay.
Thank you. And Representative Johnson, I think you have something you want to add to this as well.
Mr. Chair, as far as the accident reports go, but the last time I saw an accident report, and it just had distracted driving. They would have to put a category on that form for cell phone use and texting. And I'd like, if they did that, I think it would be great. We'd actually get real good information, but it needs to be distinctive between cell phone use and texting or data use. That way we'd get a true indication whether it's talking on the phone or actual texting or looking stuff up. But it could be done on the state accident report form, but that's something the state would have to put into the system.
Very well. Thank you.
Thank you, Mr. Chair. That's an excellent suggestion. I appreciate that.
Very well. Are there any other questions? Representative O'Neill.
Thank you, Mr. Chair. So, it's unfortunate that we've added what I deem as a rather controversial, I know it didn't mean to be controversial, but it is rather controversial piece that the previous testifier kind of referenced when we were talking about gender, we're talking about ethnicity and race, the study portion. And I would just ask, I've kind of stated my piece about why it's controversial, the fact that we're using the word gender when that's not even on our driver's license. It's the word sex. Gender is not defined in statute. Sex is. Gender could mean a multiplicity of things. We had a committee hearing yesterday or the day before. Was that just yesterday, I think?
I think it was this morning.
That was this morning. Wow. Oh. That tells you how long we've been here,
I feel you.
talking so much about gender and what that means and what it doesn't mean. My ask would be if we could change the word back to sex, which is actually what is on our driver's license, which is something that when a state trooper does pull up, I actually did a ride along just a couple weeks ago, a couple months ago now, with a state trooper, and they have all that data right there. It's right on your driver's license. It's something that can be easily pulled up. Gender's not. Gender is something you're going to have to ask the person, how do they identify? It's much more complicated. I have concerns about the race, ethnicity, and all of that as well in the study. And I understand you're trying to get at someone's perception. I feel like we're going backwards. I mean, you've got all this implicit bias training. The officers are trying to be neutral on everything, and now we're saying, no, now pay attention to it. So I just feel like we're going backwards, and I just ask that we can maybe consider that. And I realize that this bill has another stop, and it's coming back to judiciary, so we'll be talking about this again. But I just wanted to point that out, that this bill that we want to be so supportive of has now become controversial in my view.
Thank you, Representative O'Neill, and obviously the author of the bill is hearing the testimony, and we'll consider the comments of this committee if the bill proceeds. I must say, as someone who moved the author of the bill, that there's nothing about this study that stops the bill from doing what it should do, which is to be real clear with the public, it seems to me, to be real clear that it will be a violation to use a cell phone while you're driving, and that will be an actionable cause for being stopped and for having our justice system then take the steps that we do when people violate the law. I see the author nodding his head. I don't think you would have accepted an amendment that would have gutted or weakened your attempt to make the public safe in this regard. But certainly you've heard the testimony here, Representative Hornstein. If there's a better way to do things, that is our duty as legislators as we move legislation forward. Are there any other questions? Representative Pinto.
Thank you, Mr. Chair. And I just want to, I guess, build on and reiterate what you were saying, Mr. Chair, that I really view the addition of that amendment as being a really helpful thing, that really strengthening an already very strong bill. I just want to emphasize the point that, and this is one of the reasons I really resisted the secondary amendment, is that there's nothing in here that affects the interaction between the trooper and the driver. This is really assessing these important points that have been made by the bill's author and by the chair about just the concern about there being disparities. And so in that way, I guess I'll disagree respectfully with Representative O'Neill that it seems to me that and concerns expressed by others as well. But what really matters is the perception by the trooper, by the officer, and simply having that information. And so in that way, and I was looking, Representative O'Neill, at the definitions of sex and gender, and make those distinctions that in fact how what may be in the mind of the trooper is the information that is recorded. It's very explicit that there's not supposed to be any interaction based on or a discussion or asking anything of the driver, which might impact the stop, but instead simply using their observation. So in any case, I think this is very strong. I don't view this as being problematic at all. In fact, view it as being very helpful. And I'm so grateful to you, Representative Hornstein, for the bill, and certainly for the families who've been pushing this. And boy, I sure hope that this is the year that this can become law. So thank you.
Very well. Thank you, Representative Pinto. Any other questions or comments? Representative Johnson.
Chair Mariani, this is a bill that I know is going to pass. Overall, part of it I support. We've heard some very emotional testimony, but the tough part is we have to overlook the emotion. We have to legislate on facts, because when you do go by emotions, we usually get it wrong. I do have some concerns on this, and anybody's asked me, I've always told people, I don't want to disenfranchise the low income and even the middle income. I don't know if you know it, but I looked it up today. The average age of a car in Minnesota is 12 years old. Bluetooth and sync and all that technology didn't start even being installed in cars at a 50% ratio till about 2014. In 2016, only 86% of the cars made were even installed. I recently purchased a car, the 2008. I've tried 3 different items to try to get that one touch in my car. I can get down to 3 touches when I'm down here in the Minneapolis, St. Paul area. I get out of the metro area, it doesn't work very well. And if I don't have in a 3 LTE area, my Siri on my phone doesn't even work at all. And you get outside the greater metro area, we have a lot of areas that do not have LTE. So Siri will not work to make your phone call for you. So I struggle with this because I'm trying to find a way to get this to work and work throughout the state of Minnesota. So those who aren't, who can't afford a car that's less than 3 years old, 3 to 4 years old, that has this technology. Yes, can I get it for my $3,000 beater? Yeah, but once I figured out the cost, it's $1,000 to get it installed in my car. So it makes me struggle. Are we setting this up to be a huge disadvantage to the low-income people in the state that cannot afford a car that has this capability, forcing them to break the law that we passed. Now, Representative Considine has a bill coming up that was pretty much similar to what I had in the omnibus bill last year. And I think that's a good bill, a good way to go. Listening to the testimony, it's very heartbreaking. And last year, listening to all of it, the biggest thing at the end of everybody's testimony was the lack of penalty for the person who was driving distracted. They were getting just a ticket. They weren't even getting jail time. And the bill that Representative Considine has solves that issue. Yes, is hands-free coming? Absolutely. But we have to make sure when we do that, that we don't disenfranchise people.
Thank you, Representative Johnson. You and I have had a short conversation about this in passing in the hallway, and I actually share some of your concerns in this regard. And absolutely, like you, not meaning any harm or ill will or spite to the victims and their families and their beloved lost ones. It is the nature of lawmaking, right, that we often have to wrestle with all sorts of different outcomes of our laws and how they're applied, et cetera. Quite frankly, it's part of the reason why I really did want to push this data provision so that we understood, what is going on in terms of the broader society's understanding of who's driving. Doesn't quite get at the issue that you've raised, which I think is a righteous issue. I will support this bill, and as you indicated, I suspect, if not all, most of us will, and it probably will be successful. But I think it is important to raise, those areas of concern. I can certainly allow, the author of the bill to comment, but it looks like you also want to add something to that.
I also wanted to add, I had another group contacted me because of the way the definition is in the bill. Finally, I got in front of me. But for it's a two-way communication device. Some industries have gotten in touch with me between taxi cabs. Some of our cities have talked about it. With the two-way radios in the vehicles, they use a radio. It's a handheld communication device. Instead of having mounted radios in the car, they've gone to handheld portable radios. They're concerned, and along with the ham radio industry, because they're not securely or affixed to the vehicle, because they're handheld so they can take them with them, they're going to be affected by this bill as well. And it's the school bus operators, it's the taxi cab drivers, it's the garbage delivery people with the radios in their cars that it could affect it, and that's what their concern is. I just want to make sure it's not intended to do that.
Okay.
Chair Hornstein?
Well, thank you. I mean, I guess I would respond to several of the comments made, maybe all at once here in a package. First of all, I think that Representative O'Neill and Representative Johnson bring up valid concerns. And, I just wanted to say, at least, in terms of the research I did after the chair and others, not just the chair, have expressed some issues around profiling. I, checked with the National Conference of State Legislators and others, and I learned quite a bit over these last few weeks. One is that the state of North Carolina has, on a bipartisan basis, authorized, actually many years ago, the same kind of study that we're talking about today, actually even far more exhaustive. And they got lots of really important data out of that. So this is not unprecedented. I also learned that Minneapolis and St. Paul are doing this kind of data collection. And it has gone well, and it's been very valuable, and it's been very transparent. And so this is just, a very small study with one department measuring, some data on one particular infraction. So, I'm I feel it's important. Again, I've heard it among my constituents. We're having a very robust conversation in the city of Minneapolis right now about traffic stops. And this is something that I think the police and the community are engaged in a very constructive way. So you thanked me, Mr. Chair. I want to thank you for raising this. And again, I've learned a lot over these last few weeks about it. And I think we came up with something that I think can address this concern and start a conversation. It's important to have this conversation here at the state level. So, again, I think with gender and sex, maybe we, I'm willing to take a look at that. The North Carolina bill that I somewhat modeled this off of did have that. So, that's why it's here. But we can have a conversation again with the St. Paul and Minneapolis departments that are doing this kind of data collection and see if they include that, and if so, how they use it. So I'm willing to follow up on that. And I think, again, and Representative Johnson, you raise a very valid concern about issues with people that may not be able to afford some of the technology. I know that, we're still talking about something that maybe can affix the phone to the dashboard like the Lyft and Uber drivers have. There are some cheap, relatively inexpensive alternatives as well. But it's a valid concern, but I don't necessarily know. I hadn't heard that I don't think it would cost $1,000 necessarily to convert a car. But it's a valid concern, and there are alternatives, and I think we need to look at those. And to the last point you made, Representative Johnson, I think that I don't think this necessarily covers, and we have some experts here in the room that could comment, and I want to answer your question. I don't think that we're really looking at that sort of ham radio operation, but I do want to introduce to the committee very quickly and briefly, Mr. Chair, because I know you have other business, Paul Ossen from the Minnesota Safety Council. His organization is one of the oldest and established groups in the state that works on traffic safety, and he's been very helpful in the development of this bill, and I think can answer your question, Representative Johnson, better than I can. So, Mr. Chair, if Mr. Ossen could answer that, I would appreciate that.
Please, thank you. Welcome to the committee, Mr.
Thank you. For the record, my name is Paul Ossen, AASEN. I'm the president of the Minnesota Safety Council. Mr. Chair, Representative, our understanding is that the smart cell, smartphone penetration in the market is now about 85%. And so that means that, 85 out of 100 cell users are in fact holding a device that can connect to other devices much more readily, so that helps with the concern you raise. I drive a 2012 car. My phone connects to my car. I used to drive a 2007 vehicle. It had a rudimentary early kind of Bluetooth connection that did not work with a contemporary phone, but it had a headphone jack. And so I went to the dollar store and spent $2 on a cable and connected my phone from the headphone jack directly to the dash and was able to use it that way. So there are alternatives. They aren't absolutely across the board. It's not, not every single phone. My mom carries a flip phone. She's 89 years old. That's not going to connect to her car. Mom is also not going to be texting while she's driving, thankfully. And that's the big underpinning to this whole issue is if you feel the need, if you must use your phone while you drive, and I can't underline the if you must, then please use it hands-free. Don't have it in your hand. That's really the goal of the bill in total. The radio issue, this section of law does not affect radio use. If you look at some other states' legislations, they have very complicated hands-free bills that include all kinds of radio systems. This one does not change the radio system regulation in this state. You do potentially have the issue of somebody being mistaken for having a device in their hand, but I think we run that risk with a sandwich or a hamburger as well on some level. So it's not absolutely perfect, but it does not directly affect how those are used.
And Representative Johnson.
Chair Mariani stuff. I just wanted to make sure that the intent was placed in the record, so we have that if it should arise.
Very well. Thank you, Mr. Austin. Any other questions? Chair Hornstein, if this motion is successful, your bill will move then to the Judiciary Committee. That offers you yet
Correct.
another opportunity
Yep.
to address any of the issues that have been raised here if they need to be addressed. And a number of us do serve on Chairman Lesch's committee. So with that, I offer you the last words, and
Well,
I'll take the vote.
Mr. Chair, members, thank you. You know, I always learn a lot at these hearings, and it's helpful to have the different stops, and you know, we can make a good bill better, and I think we've done that today, and certainly there's some outstanding issues that should be addressed, and I will look at that very closely. And so I just wanted to thank the committee for hearing the bill and for your, you know, the excellent discussion and the questions that we've had, and I ask for your support.
Terrific. I'm going to wait a few seconds while a couple of our colleagues come down, because we're about to vote. Who made the motion? Do you recall? I'm trying to recall who made the motion on it. It's been a,
Mr. Chair,
who's not here. Okay.
Mr. Chair,
Representative Lucero.
do I have an opportunity to ask a few questions?
Representative Lucero, we're about to vote. Good time to have asked those questions.
So I made it by the hair of my chinny chin chin.
Would have been good if you had been here earlier when we had a lengthier conversation. I will, I'll be malleable and give you about a minute to do so.
I appreciate that. I won't ask any questions, just some comments. And I appreciate the indulgence. Several of us are actually sitting up in another committee right now. We're at a bill hearing, so.
You're correct, Representative.
So I just want to go back to the prior conversation that took place earlier, where we had the commissioner making some comments in regards to law enforcement. And as one who has a law enforcement degree, having gone to school, having gone through skills, and was licensed by or gone through the post test, absolutely agree with the commissioner's comments that law enforcement professionals have a high degree of training to see and perform their work without regard to race, ethnicity, et cetera. And the part that's alarming to me is, in fact, his comment was law enforcement professionals do not act on race and ethnicity in making the determination to pull somebody over, for example. What is concerning to me is, regarding the amendment that was adopted, is it does the opposite. It takes those law enforcement professionals who have years of training to view scenarios and situations with those lens on, and now is specifically directing them to do just the opposite, to view the scenario with the lens of race and ethnicity. And I think that creates a dichotomy that we just need to be concerned about with the bill in its present form. Then the next thing I would just draw attention regarding the bill language, it's on line 1.17 and 1.12 that speaks about the beginning and end of this temporary data gathering. So it begins in August and ends at the end of the year. So that is a 5-month period. And so it's a very small window. And as we know, with the climate here in Minnesota, the different seasons, things can be different. And so we have to be of the understanding that the data collection that's going to take place is only 5 months of 1 year. Second, per the prior conversation, it's the state patrol that's going to perform this. And that's on line 1.19 to 1.10. And the state patrol is overseeing certain highways and interstates in Minnesota. Now, can they go all the areas? Absolutely they can. But their primary focus is not going to be local residential roads, municipalities, et cetera. And so we also have to be cognizant that the data gathering that's going to take place is going to be skewed to one portion or segment of Minnesota rather than cities, local municipalities, et cetera, et cetera. So I think the data that would be collected, it certainly isn't going to be scientific in the data set. And then second, it's going to be based on perception. And then as the conversations that I heard here, and unfortunately, I disagree with the commissioner when he said we would then take the information gathered from a subset of information based on perception and then began to look at that, how we can enact policy. So now we are going to be basing policy on this, in my opinion, flawed information, flawed data. And I have a lot of heartburn over the bill in its present form. So thank you, Mr. Chair.
Thank you, Representative Lucero. We did talk about these points earlier, except for the seasonal one, and you might be singing after my heart because I certainly would like a longer period of time, quite frankly, to do this study appropriately, and that might be an issue for us in judiciary if this bill moves through. I do want to say for the record, members, and we heard from the commissioner earlier, and of course he's not here to repeat it. The whole point of, one, that profiling is in fact an issue in our society. Two, that law enforcement takes it very seriously and they work consistently to address it. And that three, one of the tools that they use in order to address it is to, like they did in North Carolina and they're doing in St. Paul and Minneapolis, is to do these kind of studies. And perception absolutely goes to the heart of the study. It isn't for any other purpose than to be able to properly help our law enforcement to be good professionals. Representative Sarah, we're about to vote. If you feel very strongly about it, we can certainly do a roll call vote if that's your choice. All right, very well. If not, then the chair, since Representative Dean is not here, moves that House File 50, as amended, be referred to the Committee on Judiciary. All in favor of that motion, please say aye. Aye. Opposed, same sign.
No.
Motion prevails. Representative Hornstein, thank you so
Thank you,
much
Mr.
for working
Chair.
awfully
Thank you,
hard and bringing
members.
this important bill before us. And I
And,
do want to thank the families that have been with us throughout the day as well.
Thank you so much, Mr. Chair and members.
Very well. Should we do Shelley or John? Probably Shelley. Yeah, where am I? All right, Representative Christensen, why don't we do you because you have a testifier, I believe.
Little.
Big. Representative Christensen moves that House File 1149 be laid over for possible inclusion in our committee's omnibus bill.
Beer is bipartisan.
Representative Christensen, your bill is before us.
I have a couple. Yeah. That's very cool. Beer is bipartisan. Especially for you. So listen to all of it. Thank you.
Okay, thank you, Chair Mariani. Thank you, members, for listening. Under current law, conservation officers can make DWI arrests if individuals are hunting while under the influence or operating an off-road vehicle or motorboat. This bill will give them the same authority as other peace officers under the DWI chapter. Currently, if an individual drives a motor vehicle while under the influence, for example, in a boat landing in a park area, that officer, the conservation officer, has to call in another officer from another agency to make an investigation and an arrest. Needless to say, this can cause time delays that prevent the conservation officer from performing his or her duties. Conservation officers are fully trained, and this is important. They are fully trained to investigate and arrest DWI, so there would be no new training involved. The DWI task force supports this bill, and I have 6 letters of support from the Minnesota State Patrol Troopers Association, the Minnesota State Patrol, Minnesota Sheriff's Association, the Chiefs of Police, Minnesota Conservation Officers Association, and my own Washington County Sheriff, Dan Starry. The bill has broad bipartisan support in the Senate and has moved on. So I ask you please to support HF 1149, and I'm here to ask questions. Would you like to hear from the testifier first, Chair?
Representative Christensen, I think that would be appropriate.
Okay, so I'd like to introduce Colonel Rodman Smith.
Colonel Smith, welcome back to the committee. Thank you for hanging out with us all day, Colonel.
For the record, Colonel Rodman Smith, Director of Enforcement for the Department of Natural Resources. Mr. Chair, members, I'd like to thank Representative Christensen for bringing this forward. So this is a change in a definition of peace officer in Chapter 169. Many different parts of the statute have many different definitions of peace officers. And so under this change, as Representative Christensen said, the current language says that conservation officers can write impaired driving for motorboats, recreational vehicles, and hunting while intoxicated. Last year, as we heard earlier from Representative New in this committee, we made a giant leap forward here in the state of Minnesota by closing the gap between recreational DWIs and traditional motor vehicle DWIs. And this is one more piece that'll help close that gap. So conservation officers are trained in all the field sobriety testing that's need to be done, so there is no cost. In fact, in the long run, this will be a cost savings, as Representative Christensen said. If a conservation officer sees somebody pulling a boat and they're drunk in a public access, if they launch the boat, we can arrest them. But if they're still in the parking lot in their truck, our officer is going to have to call a deputy, a trooper, or a local police officer. They're going to have to come out. They're going to write the DWI. And then when it goes to court, the conservation officer is going to have to go to court to testify on the probable cause, and then the deputy, trooper, or peace officer is going to have to come and testify on the testing. So this is just a common sense, we feel a common sense change that'll make our roads, waterways, and trails much safer in the state. Thank you for your support.
Thank you, Colonel. Representative Christensen.
Okay, and Colonel Matt Langer.
Welcome to the committee, Colonel Langer, and thank you for also being with us for a number of hours today.
Mr. Chair, members of the committee, on behalf of the Department of Public Safety and the Minnesota State Patrol, we are here to testify in support of this bill for all the things that I almost heard Colonel Smith say as I was distracted talking about the previous bill. But we think this is good for Minnesota. It's good for traffic safety. It's good for recreational safety. It's much more efficient. And no officer, deputy, or trooper enjoys going over and helping the conservation officer do what they're capable of doing, but the law prohibits. So we see this as a good thing for Minnesota and no downside.
Thank you, Colonel. I have a quick question. How often does this arise? Is it a regular? Is it a rare instance in your experience at any rate?
Mr. Chair, it's a good question. It's fairly rare, actually. So it's not that we're burdened to help the DNR. It just makes perfect sense. One of the scenarios I give is if an impaired driver is backing their boat into the lake to go fishing, and they back into the dock, and they're in their truck, and the conservation officer is there, the conservation officer is prohibited from arresting that driver for impaired driving. But if they get their boat in the water and hit the dock, they can take full action and arrest that impaired driver behind the wheel of their boat. And that's one of the examples that we give, as it just doesn't make a lot of sense. It's been this way for a long time, but we're happy to help the DNR anytime we can, but it just makes good sense that they can take it from start to finish.
And it seems to me, obviously, that the best outcome for public safety is that that harm doesn't happen in the first place. So I think we do have a question. Representative Mueller?
Thank you, Mr. Chair, and I think it's a great bill, and just wanted to kind of piggyback off of something that was said about the current inefficiencies and needing the two officers then to go to court, and that could be going to court twice, right? Because you would have the implied consent proceeding perhaps, and then also the criminal case moving as well. So just wanted to highlight that there's an added inefficiency there.
Mr. Chair, Representative Mueller, you're exactly correct. It's not just at the time of the arrest, it's the downstream effect of having whoever helped the DNR make that arrest is in court at the same time. So it's exactly right.
Very well. Representative Lesh, Chair Lesh.
Thank you, Mr. Chair. I was actually looking forward to coming to this hearing and finding out about this, but I'm surprised no one's asked this yet. This was an express parens put in this subdivision to specifically exclude state conservation officers at some point. So someone did it for a reason at some point, And I'm wondering who that is, and we're all, breaking bread and sing kumbaya now. Yeah, good idea to change it, but I'm wondering, someone somewhere knows why it was put in the first place. So why was that?
I'm sorry, Colonel Smith.
Mr. Chair, Representative Lesh, it happened before my time, but from what I've been told, it was a couple-fold. One was a funding issue, and at the time, conservation officers were almost entirely funded through the Game and Fish Fund and Natural Resource Fund. Since then, we do get general fund dollars. And so if an arrest in this case, if there's an arrest for DWI in a traditional motor vehicle, that time and all those expenses for that officer would be coded to general fund time. Another reason was impaired driving, and society's understanding and our training, to be quite frank, has evolved over time. And so the Conservation Officer Corps of 20, 30 years ago and the training that they had back then has changed dramatically as society has changed and our responsibility has changed. We do have the current peace officer powers as just about every other peace officer, except in this case. In rural Minnesota, if we're out working deer shiners and there's a domestic call at 2 o'clock in the morning and there's one deputy on, our conservation officer will go over and help that deputy so that they're not going to domestic all by themselves. So a long answer to your question is twofold. I think it was, from my understanding and from what I've been told, it was a funding issue. And then the other thing apart was we were going to do game and fish. We didn't really have the training at the time, and things have evolved over time when it comes to impaired driving.
It's a good question, actually. It's good to be able to have a perspective on the history of it. Thank you. Chair Lesh.
Well, thank you, Mr. Chair. And I appreciate the answer, but, it's mostly hearsay. I'm wondering if any of our researchers can tell us the year that this was included. And I don't know, I'm assuming it'd take a little looking into. This smells to me, Mr. Chair, like some chair and some committee had a very specific reason why it was excluded at some point. That's what it smells like. And because I don't get the sense, despite what the good conservation officer said, that it was just kind of, a funding issue. It looks to me like that was in there for a very specific reason, and it might have been a grudge by some member or chair or something, but there's a story behind it. I just want to know the story, that's all. It's probably a good story.
I'm going to ask our legal counsel to tell us a good story. And I'll give you a second. I can tell you that this bill came to me via Senator Clausen in the Senate, and just, a little tidbit of info of where the bill came. But Mr. Johnson.
Well, I meant, Mr. Chair, just to clarify, what I meant is from chair once upon a time, like some chair like 20 years ago,
Yeah.
whatever was what I meant, so.
No doubt. Mr. Johnson.
Mr. Chair, members, I'm afraid I can't shed a whole lot of light on this. In 2000, this was adopted. In the year 2000, the definition referred to another section under 169.07, and the definition there. That, in the last 3 minutes, is as far as I've been able to chase. If you give me a little bit more time, I might be able to provide a little additional information.
Mr. Johnson, the committee wants to hear a good story, so we'll probably come back at some point. Representative O'Neill.
Oh, thank you, Mr. Chair. So it's similar to actually what Representative Chair Lesh actually was concerned about. And so sometimes we do things and we don't always know the history. We don't know why it is the way it is in statute. And something that I just wanted to raise, because I was the chief author of a bill about 3 years ago now that changed the HRO statutes. And so the harassment restraining order, so that in fact, I think the lobbyist is still in the room that worked with me on that bill. Let's see if she's going to pay attention. We're all looking at you. Anyway, so we changed it to say just peace officers as opposed to just the sheriff's department. So I think with this change, what we've done now is we're now allowing the conservation officers to serve an HRO. And I'm not sure that that's, maybe we want to do that. I don't know, but maybe we should at least talk about that if that's something that they would like to also be included in the list, because now that they're included in the list of peace officers without any condition, now they're included in being able to serve an HRO. Now, I don't know if they can actually see the database that will be created, because I don't know what database they use, which might be another situation, but just something that we probably should think about as we change this part of statute. It's tied to other things, and that would be one thing.
It's actually fascinating, Representative O'Neill. Now you have you've piqued my interest. I don't know if Colonel Smith wishes to offer, at least a preliminary thought in this regard. Oh, okay.
Mr. Chair, Representative O'Neill, as I said earlier in my opening comments, there's a bunch of different places in statute where peace officer is defined. So this is changing the definition of peace officer in 169A, which is mostly traffic related.
Okay. Representative Mueller, I think you might have some insight on this question.
That was what I was going to say, too. I pulled up 169A, and it's limited to these kinds of cases for peace officer here.
Very helpful. Representative Sir, on this point?
Yeah, exactly. At this point, thank you, Mr. Chair. So, and that also then brings up the question in my mind as I'm reading the bill summary, and as we heard described here, we've been focusing the conversation on DWIs, but this actually, the change actually does way more than just this. It'll allow for anything as defined in the chapter that was just referenced in terms of enforcement, well beyond the scope of DWI. And I guess the bill summary, and I didn't research what the full scope of that is, I think that this committee would want to know what this change is actually going to do in terms of enforcement before we move forward. I'm just throwing that out there for the chair to consider.
Great questions, Representative Lucero. Mr. Johnson, can you help us?
Mr. Chair, members, this is limited to Chapter 169A. And 169A is the driving while impaired chapter. So this would not apply to other moving violations or any other criminal penalties. It would only apply to violations under 169A, which are DWI violations.
Thank you. Representative Johnson.
Chair Mariani, as Mr. Johnson did just explain, one thing I was going to say is that this is just the DWI statutes. 169A in 2000 was created, moved out of the 169 statutes. And I'm trying to remember back when I started my law enforcement career back in '85. Back then, DNR could not do traffic enforcement, and they were licensed peace officers. So it goes back into, probably goes back into even before we actually required licensing and post-certification, become an officer, where DNR was trained to do just game-related stuff and DNR-related stuff, and the troopers and peace officers did the traffic.
Very well. Representative Grassel.
Thank you, Mr. Chair. Boy, did you guys dodge a bullet on that one, huh? You could have been doing civil. You could have been doing all kinds of different things. But from what I know about game warden's equipment, having served as a deputy sheriff, you guys usually don't have cages in your vehicles for transport. So how have you handled that all along? You'd have to hook up with a trooper or a deputy sheriff regardless.
Mr. Chair, Representative, there's an exemption in statute for conservation officers to transport prisoners without a cage, and that's existing law. And so we do transport prisoners in our pickup trucks. If they are squirrely, unruly, then we will call for somebody to transport for us. But 99% of the time when we do transport somebody, they're cooperative, and we do have that exemption in law where we don't need the cage.
Thank you, Mr. Chair, because that was kind of my question. Are we going to need to start putting new equipment into the vehicles and such? But thank you.
Thank you, Mr. Grassel, for looking out for our target amount as well. So, Are there any other questions? All right, well, thank you, Colonel Smith, and also Colonel Langer. Representative Christensen, we're going to lay House File 1149 over for possible inclusion. You might want to check into that story because I suspect we're going to want that story.
Okay.
And hopefully it'll be a juicy one when we bring this back. So with that, we'll lay House File the chair lays this over for possible inclusion in our omnibus.
Thank you.
Our last bill, thank you, Representative Christensen. Our last bill then is Representative Chair Considine, House File 1375.
That's why we have handy dandy.
Chair Considine, I believe your motion is to re-refer House File 1375 to the Transportation Committee. Your bill is before us.
You are correct, Mr. Chair.
Oh, and we have co-presenters, Representative
Co-presenter, yes.
Pinto. This should be-
Reluctantly.
should be good.
Apparently, I'm up here as assistant counsel or something like that. I'm not quite sure, but in any case, here I sit. But
He just keeps kicking me underneath the table.
that's right. That'll be my job.
Somebody get a picture.
Just gonna do that right now.
Thank you.
It's just with the
Oh, no, that's fine, yeah. Please. No publicity is bad publicity, right? Oh, yeah.
Come on, Jeff, come on.
The bill.
Because actually, a serious subject.
Yeah, it is. For those of you that don't know, a month before I was elected, my brother was in Brainerd returning his boat. Guy blew through a stop sign, killed him. My brother was a retired Air Force officer who spent his entire adult life protecting the country. He'd finally retired, moved back to Minnesota. He'd been back about a year. When I went up for the hearing, the guy that killed him pulled into the parking lot ahead of me. They hadn't taken his driver's license. I got to court. They charged him with a misdemeanor, even though he had blown through a stop sign to do so. And honestly, this bill still would not do anything about that. I spoke, the judge departed upwards and gave him 30 days of house arrest. As someone who has had personally somebody killed, that wasn't enough. And this bill says that if you are driving the car in a reckless manner, or you are driving under, and there is a list of, once again, suspensions, reasons for suspensions. That's why I was so grateful for Representative Lesch's bill, because it took out some that I don't think we wanted to include. But if you have a history of, I'm sorry, just a second. Of driving after suspension or in a negligent manner, that the county attorney should at least be able to go for a gross misdemeanor. The maximum for that is a year and a $10,000 fine. I just don't think that's really terribly high for somebody that kills somebody. I guess I don't really have a lot more to add than that. Stand for questions.
Thank you, Representative Considine. Representative Pinto, perhaps you can add some more, particularly on some of the technical points of the language before us.
Thank you, Mr. Chair and members. I had, so as folks know, I have previously focused a lot on gender violence prosecution in my work outside the legislature, but for the past couple of years, I've been handling charging of cases across a really wide spectrum, and so they include criminal vehicular, operation and homicide, and in general, there's a standard that if there's not alcohol involved and other issues, that there's this series, and you can see this is really pretty much all in the bill of 609.2112 is the statute, and there's this series of levels of harm that's caused, everything from bodily harm, which is pretty minor, all the way up to death. And if there's not alcohol involved, then the question is whether the driver has been grossly negligent. And that's a very high standard. It's very tough to prove that somebody's grossly negligent. I see Representative Moeller nodding. And it has seemed to me that there are some circumstances where even when a driver is merely negligent, we still just at a moral gut levels believe that somebody should have a responsibility. It may well be that we say that mere negligence without anything else is something that we wouldn't want to change the law. And I will say that I suspect that every one of us at some point in our driving on a pretty regular basis is probably negligent at some point. That's a relatively lower standard. We shouldn't be, and perhaps none of you are, but it's a significantly lower standard than gross negligence. And so I've long thought that it would make sense that for certain circumstances beyond being under the influence of alcohol, it makes sense that if you're negligent plus one of those circumstances, that you should have the same accountability as if you're driving grossly negligent. This actually connects with distracted driving as being an example. I believe that we have this in here. But then also certain circumstances where someone is not being permitted to drive in the first place. They don't have a valid driver's license. So this was the structure here, and the purpose of this was to set up those series of circumstances where someone can be held liable even if they're not grossly negligent in their driving, if they are merely negligent plus some other circumstance being present. And so that's the legal structure of the bill that I worked on with Representative Considine. And so I think now together we will presumably stand for questions.
Very well. Other questions for Representative Pinto and Representative Considine? Representative O'Neill.
So I'm sorry, I don't have the statutory reference, but it equates to juvenile traffic offender. And I don't have the statutory reference, but all of the listings in my brief seem reasonable. That one was just kind of curious. Juvenile traffic offender is what I have here. And maybe my researcher can tell me what's the statutory reference for that. I'll go see if I can get it.
Is that one of them?
260B.
Oh. Being a June 260B.225.
Just when you find it, if you could maybe give the reasoning behind that and what that entails.
So this is maybe it's in the list in the bill brief. I think 260. Oh, I should, Mr. Chair, with your permission.
I'm giving our researcher a minute to
Okay. Thank you, Mr. Chair.
look for that. Please, Mr. Johnson. Yes.
Mr. Chair, members, the reference is to section 260B.225, subdivision 9, and that's a juvenile major highway or water traffic offender. So a juvenile court must find that a child is a juvenile major highway or water traffic offender, and they do that if they make any of the following dispositions with a case, which includes reprimanding a child, continuing a case for a reasonable period, requiring a child to attend a driver improvement school, recommending the Department of Public Safety suspends the license. If there are two or more of those violations, there are increased penalties in that section.
Mr.
Representative Pinto.
Thank you, Mr. Chair. Maybe one way to think about this is that rather than simply saying that any time somebody's license has been suspended, revoked, canceled, or denied, that this would apply, that instead the scheme here was to pick out certain of those circumstances. There is some concern that we want to be focusing on situations where we've got concerns about the person's driving. So in this particular example, in order to be, as I look at that statute, in order to be a juvenile highway traffic offender, the child has to have committed a major traffic offense, which is defined in another section. And so the thought, if the person has committed a major traffic offense and has a license that's been suspended, revoked, canceled, et cetera, because of that purpose, then we say, okay, now they've shown themselves to be dangerous enough that then if they're driving and they're driving negligently and they cause the kind of harm that's listed in the bill or listed in the statute, then we believe that they should have liability for that injury that they've caused. So for that particular one, I think that's what's related there.
Thank you, Mr. Chair. That helps explain what was the thought process behind that. A lot of statutory references in this, and so I'm just trying to wade my way through it.
Thank you for helping us vet through it. Representative Long.
Thank you, Mr. Chair. Just a question for Representative Pinto. Thinking about the new negligence standard, what are some examples that you can think of where there would be a vehicular homicide, but it would not meet a negligence standard?
So, and it may, thank you, Mr. Chair, and Representative Long, and I may look a little bit to Representative Moeller for assistance on this. Gross negligence, again, you have to be pretty out of it. I mean, so you have to be, like blowing through a stop sign at a very high rate of speed. That would be grossly negligent, right? Driving through, potentially driving through a red light, but not at a really high rate of speed might be merely negligent and not grossly negligent. I may, with the chair's permission, actually turn to see if Representative Moeller has any examples or help that she can provide, because she nodded vigorously before, so I may need to, I may pull her in on the basis of that nod, Mr. Chair, if she's willing.
Representative Moeller.
It has been a while, Mr. Chair, it has been a while since I've looked at some of those cases, but what you're talking about is what I sort of remember. It's almost like two things. It's almost like two steps of negligent, running a stop sign and going very fast.
Right.
It's like multiple things have to happen, and the courts have been really hesitant to find gross negligence if there's just kind of one factor. And
Chair Considine.
Thank you. When I started looking into this, I actually talked to a number of county attorneys, and every one of them had a story about somebody getting killed that they felt the only thing they could charge was a misdemeanor. Blue Earth County was a 6-year-old child in Madison Lake, and of course those people were furious. But yeah, proving that gross negligence just has turned out to be a tremendously high bar, and most of them don't even try to do so.
Thank you, Mr. Chair. So that's helpful. I think I understand the negligence versus gross negligence distinction. The question I'm trying to get at is, for the negligence standard, are there instances where you can think of where there would be a vehicular homicide, but it wouldn't rise to the negligence standard? Or is this essentially self-proving that all vehicular homicides are going to meet the negligence standard?
Chair Pinto.
Thank you, Mr. Chair. And Representative Long, so negligence is itself a standard, right? So there is something that would have to be pointed to in the driving that would say the person is driving negligently. So you could certainly imagine driving in a manner or such that you could cause somebody to be injured or even killed in a way where you are not driving negligently. So I can think actually of an example of a case where there was a case that I have to think about how many details I can provide on this, but a case where there was a gentleman who was late at night. He was dressed with dark clothing. He was wandering in the middle of a roadway was marked at a very high speed, and there was somebody who drove and who struck and who killed him. It seemed likely that this man was trying to be hit and struck and killed. And in that circumstance, so that was this person, it was no doubt that the driver's driving was what killed the victim. But there appeared to be no negligence on the part of the driver. So that would not be chargeable as criminal vehicular homicide. If there is negligence alone and there's nothing else, then I still think we have a moral sense that it may well be civil liability, but do we want to rise to the level of criminal? Perhaps not. But when there's something else involved, we would say that'd be the case. So no, yes, I can think of many circumstances where there would not be negligence, and yet there could be an injury or death. It would not be chargeable under the statute. I hope that helps for your question.
Thank you, Mr. Chair.
Representative Long. Very well. Chairman Lesh.
Thank you, Mr. Chair, and Representative Considine or Pinto. Is it your understanding that violating a statutory prohibition, even in the traffic code under 169 or something, would be categorized as negligence per se? You have a duty and you breach it by breaking a traffic law.
Mr. Chair.
Chairman Pinto.
So Representative Lesh, I would say no. I mean, if you're pointing to one of these references in the bill and what would be the statute, where it says in a negligent manner while something else is present, then I would think that'd be a pretty good argument that you could not be found per se negligent by doing the second thing, because the statute itself is describing them separately. I wouldn't read it that way, and I guess I wouldn't think a court would, but I'd be interested in your thoughts.
Well, thank you, Mr. Chair, Representative Pinto. I asked the question, but I guess I'm just wondering, because you use that example of someone, walking with a dark sweater on in a dark place or something. The cops that I know, prosecuting traffic crimes for 15 years, in many cases, will write a ticket if there's any kind of collision, because as far as they're concerned, someone's at fault, and the default statute they were writing under doesn't fall under here, but it's duty to drive with due care. So that's why I asked, because some people think that if you hit something, you were going too fast for conditions or failed to drive with due care or something, and that could, in my opinion, be negligence per se, because it depends on your perspective, of course. But that's why I was just wondering. Now, it's not in your list, but I am a person who, in my 15 years of prosecution, I had 4 of these cases where there was a petty misdemeanor violation and somebody died. The one that I remember last is a person driving west on Maryland right there, taking a left onto Western in my district and striking a kid. And it was charged as, a petty misdemeanor, and the family was distraught. Now, they sued for wrongful death that way and everything, but it's really tough thing to see and go through. And Representative Considine, I think a bill was brought up that year as well, and then 5 years before that, it keeps coming back. So the reason I just asked, though, is some of these cases are just really difficult, but that's all. Nothing more, Mr. Chair.
Indeed. Chairman Pinto.
Thank you, Mr. Chair. Representative Lesh, as I'm thinking more about your question, it occurs to me we should have many examples of this, because right now, driving in a negligent manner while under the influence of alcohol, et cetera, there are cases that are charged under that, right? And I'm pretty certain, I don't know if Representative Mueller think about this, but I'm pretty certain that in those cases, something does need to be pointed to beyond I don't mean to keep bringing you in, sorry. Something does need to be pointed to beyond the alcohol, or even something, driving without due care. If you're driving with the rest of traffic at 57 miles per hour on a 55 mile per hour highway, I would suspect, I haven't looked at this, but I suspect under the case law, that would not qualify as negligent, even though you're violating the speed limit. But so there does need to be something pointed to about not driving, by driving in some way where you're actually violating your duty of care. So anyway, I guess I would think that there would be information on that in the case law. I don't have that with me. But there obviously there must have been a lot of case law on it, because we've got lots of other examples of not just gross negligence, but negligence plus something else. We're just adding a bunch more something else's to the list.
Well, Mr. Chair,
Chairman Lesh.
not to get into a nuanced academic argument about it, but when I say negligence per se, I'm not talking about the other elements of negligence. You've got duty, breach, causation, damages. So I'm not going into the causation component. That's an entirely separate, arguable piece. But if someone could tell me I'm wrong, that's not negligent. I think I'm right. I think that is negligence per se. If you break a law that's prescribed, that is a duty. If you were driving 57 and 55, you have a duty to not breach, to not go past that. And then the breach component is that you did drive 57, you breached it, so that is negligence per se. That doesn't mean you're going to be able to collect that or anything. It's just the prima facie case component of it. Someone tell me I'm wrong.
Chairman Pinto, we're going to engage counsel here. They may have some thoughts.
Can I just
Or,
quickly comment
House
on?
counsel here. Chairman Considine.
Chairman Lesh, that was my initial, what you're saying is where I wanted to go. If you break the law and you kill somebody, that was what I started off with. And frankly, Mr. Johnson gave me a couple of examples that I didn't think were fair, so I backed off of that. And to be quite honest with you, I don't believe in my brother's case that it would be covered under this. I think they would still say this man, 89-year-old man, ran a stop sign and killed your brother. We're going to charge him with a misdemeanor. But frankly, Mr. Johnson gave me a couple of examples that I thought were didn't work for me. So that's why I backed off all law breaking because, well, I won't go into that, but I thought he did a nice job on that.
Thank you, Chairman Considine. Mr. Johnson?
Mr. Chair, members, I think I'm answering the question of negligence per se. It's a civil standard, as you know, Representative Lesh. And for negligence per se to attach, my understanding in the civil world is that the statute must be not only apply specifically to the situation, but that statute must have been designed to protect the person who was harmed in that particular situation. So if you have a situation where violating a traffic law was designed to protect the individual who was particularly harmed, negligence per se could apply. If you do not have that full situation, then negligence per se would not apply. That does not mean that it would not still be negligent. For example, driving 5 miles over the speed limit could still be negligent, but you might have to prove that that was not meeting the standard of reasonable care to reach that level of negligence, not simply rely on the violation of law as you would in a negligence per se case. Okay.
Very well. Are there any other questions? If not, then I'm told, Chairman Considine, that we need to modify your motion, that the bill needs to go to Ways and Means. We refer to Ways and Means. And thank you, Minority Counsel, for pointing that out to us. Any last words as we get ready to vote?
No.
No, thank you, Mr. Chair.
Yeah, thank you, Mr. Chair.
All right, very well. Then Representative Considine moves that House File 1375, I have the right number because it's late, it is, 1375. That House File 1375 be referred to the Committee on Ways and Means. All in favor of that motion, please say aye.
Aye.
Opposed, same sign. Motion prevails. Thank you, representatives. And Chair Considine, I began this day by walking in on one of your bills, and I'm ending it walking away from one of your bills. So there's a sign there. I don't know what it means.
I'm authoring too many bills, that's what it is.
Members, until tomorrow, this committee stands adjourned.